Hey everybody, welcome back to DDJ's Inferno, the weekly show where we discuss issues relevant to men. And of course, this week I'm going to be doing the Layman's Legal Clinic with veteran attorney MGTOW Esquire. MGTOW Esquire, introduce yourself and say hello.
How you doing? Can you hear me?
Yes, of course.
Okay, good.
So welcome everybody. This is going to be, I believe it's our fourth installment of the Layman's Legal Clinic, isn't it?
You broke up there. I think this is the third or fourth. I'm not certain exactly.
Yeah, it's like the third or the fourth. I don't quite remember. But yeah, it's going to be, I think this one's going to be a good one. I know we were kind of talking about before about what we were going to go over.
Sure.
TFM actually talked to me last night during the TFM show that he had been getting some questions about domestic violence. So I thought that while we're talking about other things, we can kind of discuss that as well.
Sure, absolutely.
So, but before we jump in there, I just kind of wanted to make a couple quick announcements. First and foremost, if you guys haven't seen my video, Free Speech 1, Twitter 0, you should check it out. It turns out that Jared Taylor, who is I guess you can call him like a white nationalist or a white separatist, he's with the American Renaissance Project, and he sued Twitter for banning him for hate speech. And what's interesting about his lawsuit is that the arguments used in his lawsuit that was filed in February 2018 were the same arguments that were contained in my first video, The Social Media Constitutional Crisis, from October 2017. So approximately 4 months earlier. What's interesting about that is that every time a social media giant has been sued, either it's been Facebook or it's been Twitter or it's been YouTube or Google for that matter, they've always lost. And what makes this case interesting is that the arguments that they were used were different. And Twitter filed a motion to dismiss and they lost. And what was interesting is that the judge had said something along the lines of that basically it was a public interest lawsuit and that it was extremely, basically it was a free speech lawsuit, and it was a classic public interest lawsuit. So they actually won. And the other side of it is that they also got sued for false advertisement, which the judge said that, yeah, that's important as well. So I think it's going to be an interesting lawsuit. It's going to be interesting the way it plays out. And I'm really excited to see it happen. But I think the other piece of it is that because this motion to dismiss failed, I personally think that the discovery phase is going to get very, very interesting. And I think that Twitter's going to go out of its way to hide from discovery. So with that in mind, MGTOW Esquire, kind of weigh in on that. Tell me what your thoughts are.
Well, the interesting thing is it wasn't just a motion to dismiss. This was a SLAP lawsuit, strategic lawsuit against public participation, or rather anti-SLAP is what it was, strategic lawsuit against public participation. So they were alleging that Jared Taylor's lawsuit was just a strategic nuisance case designed to chill free speech, or rather that he's doing that to just screw them up. And that would be a motion to dismiss, but it would also include very heavy sanctions for both the plaintiff and for the attorney who filed the lawsuit. I've seen a few of those. I've actually prosecuted a few of those. They frequently come. The lawsuits that I've seen that were successfully litigated as SLAP lawsuits or anti-SLAP lawsuits, the bare bones complaint basically allege that what was all the defamation elements of it are basically, it's kind of like, you steal somebody's wallet and then you call them a thief, and then you sue them for their wallet back. And the lawsuit that comes back as a counterclaim is, you called me a thief. So right. The anti-SLAP is exactly what you do to get rid of that. Because, you're allowed to call a thief a thief.
Exactly.
So, and that's exactly what happened. It looks like this court actually ruled correctly. So that's a shock, because this is occurring in Dogshitistan.
Exactly. And the thing is, It's amazing because it's in state court.
If they keep this shit up, we may have to revise our moniker, DDJ.
I know. but you know what? They've got a long way to go. They've got to get the shit off the sidewalks. They've got a
long way to go.
Yeah, long way. I mean, but again, baby steps. Maybe. Who knows? Maybe they'll split into 3 states.
It's a tiny gleam of hope in an incredibly dark pool of shit.
I would agree with that completely. But it's interesting because, again, I think that Twitter was hoping to avoid the discovery phase, and I think the discovery phase is going to be damning.
They're going to get hammered flatter than Jesus. They're going to get hammered in discovery. They're going to be hammered to a singularity. There's not going to be much left of them once the discovery phase is over, especially these days with the electronic discovery that's available.
Right.
Lawsuits like this, they're going to have to turn over damn near everything. And I know how much that stuff costs. I've worked with large firms as an assistant because what they use, stop me if I go too far afield, but what they use is this software like Relativity, I think they call it.
Yep.
That creates an algorithm, and you have like 100 or 200 lawyers looking at the paperwork that might be responsive, and you're teaching an AI to search through documents that are so voluminous that a human being would take 50 to 100 years to actually sift through the discovery, so the AI can actually get the responses back out. It's amazing software.
Right.
But the lawyers are just looking at documents and saying, this document contains something that's privileged. This document contains something that is responsive to the discovery. This document contains something that is not responsive. And you're just basically teaching the AI to search all the terms in every document that could be responsive inside the entire company. And the legal fees alone are going to be just for finding out if they can respond with these documents. It's going to be millions and millions of dollars just for that.
Well, and what was funny about it was the judge asked Twitter, and they said, look, you guys claim that you can ban or suspend anybody's account for any reason at all. Does that mean that you could ban or suspend a member of the LGBT community on the basis of that? Or that you could ban a person of color or another protected class? And Twitter said, yeah, that's exactly what it means. And then they're like, but we would never do it.
I love it. This judge, I swear, he actually deserves his judge's robes.
Yes.
It's amazing. He actually understands that classic Latin motto, understand the other side. He's doing what a lawyer should be doing.
Exactly.
Lawyers, and you and I spoke about this recently,
right.
Lawyers are on the theoretical side of the legal thing, and judges have to be in that realm. If they're not, because they have to be able to look at both sides. And so many of them these days, they are so steeped in social justice ideology that they can't look at the other side. They simply can't. They're ideologues, and they're always going to rule the same way. Whoever they deem to be a victim, and it's almost always the same groups, is exactly who they're going to rule for every time, in the hopes of making the world a better place.
Well, and I thought
it's a better place for who?
Yeah, and I thought the funny part about that is that Jared Taylor can actually debunk that right there and say, look, Your Honor, Twitter's lied to you because they've suspended Milo Yiannopoulos or Yiannopoulos. He's gay. They've suspended me, a masculine presenting transgender lesbian. They've suspended other people for a variety of reasons. And it's like, wait a minute. And they don't ever give the reason. Here's the thing. They don't ever give the reason for the suspension. So the presumption is discrimination if that opportunity is there.
Oh, yeah. Well, once it gets to the discovery phase, it's going to be blatantly obvious why they're discriminating.
Right.
Total viewpoint discrimination. And that's the end of the case. They're probably going to wind up settling. Hopefully, Taylor is not willing to settle.
I brought that up last night. I said, the Twitter is going to be making settlement offers from now until the cows come home. But if Taylor's
and they're going to
smart,
get huge.
Yeah. If Taylor's smart, if his dick isn't in a purse and if his backbone isn't on layaway and his legal team actually has a set of balls on him that functions, they're going to take this to trial and they're going to get a ruling. And then what they're going to do is they're going to continue to push this, because the thing about it is this particular lawsuit has the ability to change the face of social media, especially in light of Packingham versus North Carolina last year from the United States Supreme Court, where they said that social media platforms
I didn't hear the reference to the case.
It's Packingham versus North Carolina. And
I only got North Carolina. I'll look it up.
It's Packingham versus North Carolina. But it's the United States Supreme Court, and the Supreme Court found that social media platforms are considered public forums for purposes of free speech. It's huge.
I'm going to read that case as soon as I can.
And I think the other side of it is that
awesome.
You had that federal judge recently that ruled that Donald Trump couldn't block anybody on his Twitter.
Yeah, that's also true. The facts that are coming to light with these kind of cases and the new rules that are coming through are going to make this Taylor case fascinating.
Yeah, I think so.
We indeed live in interesting times. This is awesome. It's a good time to see. Yeah.
And to kind of to switch gears a little bit, I also kind of wanted to touch on the Southern Poverty Law Center. So apparently,
I got to give them credit. They actually did something smart for the first time, I think, and since I've ever heard about them. First thing that I've ever seen them do that was smart. Yeah, they settled with Majid Nawaz, $3.375 million. Yeah, I'm surprised he actually settled.
Well, they didn't ever file a lawsuit. That was the thing that made that situation so powerful. Was that all he did was he had his attorneys send a demand letter. And the settlement came as a result of a demand letter. They never even filed a lawsuit. They never saw court.
Holy shit! That's a fact I did not notice.
Yeah, and here's the thing. According to, I think it's either the Daily Caller or the Daily Wire, they were saying that, it was PJ Media. PJ Media did an article about this, and they said that there are now 60 different organizations that are considering suing the Southern Poverty Law Center for the same reason. Because they've just made themselves vulnerable.
Blood in the water.
Blood
in the water. And they are an absolutely horrible organization. So it would be nice to see them suffer a little bit for all the damage they do. And the unbelievable credibility that they receive from the media.
Well, that's because they downplay the credibility that they lost with the FBI. You see, back before 2014. The Southern Poverty Law Center actually was listed by the FBI as a place you can go to find hate groups and things like that. And they're responsible for some notable lawsuits, some of which actually did some good back in the day. But they've become a social justice shithole, just like every other leftist organization. And so the FBI, at the request of Congress, separated ties with the Southern Poverty Law Center and said, you guys are too extreme on the left, so we can't associate with you anymore.
Yeah. So it's curious to me because the thing that I can't quite wrap my head around, and I really would love to look into the history of the Southern Poverty Law Center. Was it ever actually about Southern poverty?
Yeah. It was basically it was formed. I want to say it was formed right around the time the civil rights stuff was going on, right before civil rights got co-opted by feminism.
Yeah, because what does Southern poverty have to do with hate groups? That's the thing that confused me when they first came to my attention. I think that what it was is it was civil rights, and it was for the Black Civil Rights Movement. I think that's why it was formed, because originally they were going after like the KKK. There was a notable lawsuit with the KKK. That makes sense. Yeah, I just don't know much about their history.
Connected again. So gotta love Wi-Fi. Sometimes it's got some entertainment value. We'll just give it a second to make sure that we're there.
All right.
Just want to make sure we're set up.
Let me know when all systems are go again.
Yeah. And we'll kind of cover the last couple seconds just to make sure we don't miss anything. This happened for some reason. The Wi-Fi connection that I have is not great. So we're going to just basically focus on trying to make sure that everybody is on the same page. So just a second here.
Sure.
All right. So it looks like we're back up and running. I'm going to go ahead and put a OBS took a shit link and link those two things together. And we'll just jump right back in. So Sounds good. So I think the Southern Poverty Law Center, when it came to this idea of focusing on civil rights, they did some good work when they went after the KKK. They did some good work when they went after some of these other organizations back in the day, but they just rebranded themselves as a social justice shithole, and that's a problem.
Yeah. Not mine.
Oh, somebody's phone was ringing. Oh well, we got it handled.
Okay, good.
So, so that's an issue, and I think that you see all these organizations that are doing that. They're pushing so far to the left that traditional civil rights have been left in the dust, and it's an actual shithole. That's
why free speech is under attack every day these days. It's nuts.
Exactly.
I mean, free speech is the archetypal human right. It absolutely is. It costs people nothing to allow other people to say their piece. And yet you get these social justice warriors who believe you should be deplatformed if you believe certain things. No, that's not the solution. Because if somebody doesn't know what the hell they're saying or they're talking out of their ass, let them talk. They'll prove themselves to be complete blithering idiots.
Well, exactly. And I think that's one of the reasons why they're going after censorship so badly, because they really don't have a response. And when they do respond, they make total fools of themselves. And we see this all the time in the media.
Well, the best thing they really got, the best argument they've got is the inarticulate autistic screeching at the sky.
Right. I would agree.
I think they can compete with infants for intellectual processes when they do things like that. It's the most ridiculous thing I've ever seen.
Right. Well, and like I said, I think that these are glimmers of hope. With the Twitter lawsuit, I hope for the best. I hope that Jared Taylor and his organization don't settle. I hope they just take it completely to the wall and hold it all down. I hope that these other organizations go after the Southern Poverty Law Center. And frankly, I think that given the defamation and the payout that the Southern Poverty Law Center is being forced to pay out with this situation, with the defamation that they've already been admitted to, I think that YouTube and Twitter and Discord and these other organizations need to part ways with the Southern Poverty Law Center because they've demonstrated they can't be objective.
Well, that just means that, actually, given the fact that you don't file a lawsuit because somebody's going to do something bad, you file a lawsuit because they've done something bad. I think that settlement is blood in the water, which will entice correctly maligned people to have a nice cause of action against Google, Twitter, Facebook, and anyone who the Southern Poverty Law Center has maligned gets to nail those guys as well. And I was talking to Lone Wolf earlier. It looks very much like, attorneys are always looking for the deep pocket. Well, in this case, there is one. Odds are good, and I'm just speculating here. I have no bloody idea about Jared Taylor, but odds are good that law firm is taking that case on a contingency basis. If that's so, the only thing that's the question is, what kind of a war chest does that law firm have? From a strategic standpoint, it's probably not going to be Jared. Jared Taylor has no incentive, unless he's got financial trouble, which let's hope not. But unless he's got financial trouble, it's the question of what kind of juice does that law firm have? If they have the juice to take this all the way to the Supreme Court, I would say Twitter is fucked.
Well, you also have to remember, too, that there's a growing number of not just white nationalists, but there's a growing number of conservatives as well as people on the alt-right that have deep pockets that could help fund this sort of thing. But the thing that's interesting about the Jared Taylor lawsuit is they've actually opened up like a GoFundMe site, or I think it's a fundraising site of some kind. I don't know if it's GoFundMe or not. But they're actually fundraising for the lawsuit, and they've been fundraising for it for quite some time. And they continue to fundraise for it. So they have the ability to do that, plus whatever they get from the fundraising.
Oh, and I should mention, because it is related to what we were talking earlier about the anti-SLAPP lawsuits. Losing such a motion, legal fees and punitive damages are mandatory.
Oh, damn.
those, from the ones. What's something's playing in the background? Do you hear that?
Not me.
That's not me. That's weird.
Maybe it's the voices in your head. I'm not sure.
I think it's, they're the ones that are telling me to do things, and I rarely do them. I don't know. I think that's my conscience, but
There you go.
I am an attorney after all. We're not supposed to have those things.
All right. Lone Wolf, are you guys hearing anything in the background?
I think I'm just going to close everything in the background just for my peace of mind.
There you go.
That would be easier.
Well, easy's good.
Yeah.
While we're switching gears here, let's talk about the Q&A for a second.
Sure.
So it turns out that even though the Bukkake choke slams are working for people to turn those in for questions, there's been some problems with Streamlabs, or at least Streamlabs is currently smarter than me. So we're going to be doing the Q&A from the chat itself. So if you have a question during the Q&A section for MGTOW Esquire or myself, basically all you have to do is type in question in brackets and caps, and who the question is directed to, and both Lone Wolf and Rose will grab those questions. We'll go from. So just so that that's out of the way and forward.
Please use proper grammar.
Yeah. So, but that's kind of where things are. So just as a kind of an FYI. And then with that in mind, let's kind of jump into the real reason that we're here. I mean, obviously there's a lot of current events that's happening, and I think it's important that we actually kind of address some of these things. But I mean, the real reason we're here today is to really talk about family law and to talk about just some different legal issues that have come up in legal situations, as well as kind of delve a little bit into general tips on domestic violence defense and just kind of best practices types of things. So with that in mind, I know that there were some things you wanted to bring up, MGTOW Esquire. So why don't we go ahead and jump right in? Go for it.
Sure. I remember reading the chat discussion from the first Layman's Legal Clinic, and I realized that a lot of people have an unfavorable opinion of my profession, which is largely deserved. But the truth of the matter is that it doesn't have to be that way. If you marshal the facts and you bring a case in to an attorney, and you do as much of the legwork as you can when you present it to an attorney, you'll find that the legal fees they charge probably won't be cost prohibitive. So that, because the reason is, I have had numerous cases come across my desk where somebody represented themselves, went in, got horrible results, and I'm trying to play catch up and fix the case before it winds up with a horrible result. The amount of time it takes to fix something that's gone wrong before is astronomical compared to the amount of time it takes to fix it right the first time. And if you handle a case from cradle to grave that's just brought in, my wife is doing this or that, or the other way around, I guess. But if you actually marshal your resources and speak to an attorney, not every family law practitioner is going to charge you to just talk. Most of them that I know will talk to you for free for a little bit of time. Be patient with their processes, because in my firm, you speak to somebody other than me first to gather the data, and then you meet with me for a brief window of time, and I've already reviewed your file. So I can give legal advice for that 30 minutes, and then you make the decision as to whether you're going to hire me or not. And just as a practice of my firm, we don't want to charge more than we have to. We charge what we have to, not more. And that's just to make sure the lights stay on. Because, if I go out of business, I'm not exactly helping anybody, am I? So, but you gotta understand, and this is the best analogy I can think of is, if you have appendicitis, very bad appendicitis, you're not going to want to go to ask a doctor how to remove your appendix and then try and do it yourself. It never ends well if you were to do that. And many of these things seem on the surface to be relatively simple. Well, they are simple to a point, but they're not easy by any stretch. Any layman who actually wants to contemplate handling these matters might want to look up things like the rule against perpetuities and see if they understand it and can articulate it, or the hearsay rule and all of its exceptions. There's an awful lot of data that you get in law school and in paralegal training that is just not something that you're going to intuitively understand.
Well, and I also think too that it's important to remind people that it's important to determine the difference between the legally relevant facts and the emotionally relevant facts. Because when you're the client and you're trying to communicate your case to the attorney, it's important to provide the procedural history of the case with a little bit of, conversation about how that's impacted you. But if every other sentence is, and then I had to go drink, or then I was upset, or then I was, well, now all of a sudden you've taken a 10-minute presentation and you've turned it into 25 or 30 or an hour. And when you start talking about those emotionally relevant facts and if you focus on them, you start tangenting, and then you start talking about things that are irrelevant to the case, at least in the beginning stages. The other thing that I would say is that not all paralegals are made. I actually had a conversation with a paralegal the other day, and I called up on the phone, and I was basically helping a friend find an attorney. I spoke with the paralegal, and I laid out just kind of the basic elements of the case. And this person didn't understand what it was I was saying. And I was speaking in legal terminology, but I wasn't speaking at a very high level. It wasn't like to anybody who works full time in the legal profession for more than a year, they should have completely understood what it was I was saying. Now, the reason I say that is because when the person didn't understand, I was like, well, do you have somebody with some legal training that I can speak with, or do you have an attorney that's available? And the person's like, well, I'm the paralegal. And of course they got offended, and they were like, I'm the paralegal. And, I usually field these cases beforehand. And I said, yeah, but unfortunately you don't understand what I'm saying. So I'll try to explain it differently for you.
Yeah.
So,
that's the Mayor Koch, best insult I've ever heard. I can explain it to you, but I can't understand it for you.
Exactly. And so, but I think that it's so, when you're a legal professional, or you have some legal training, you want to speak to an attorney. You don't want to speak to a paralegal if you can.
Sounds like that fellow is lucky there is no such thing as paralegal malpractice.
Oh my God. Well, and of course, yeah. And of course I never got to speak to the attorney because this person got rubber. So whatever.
These days, the butt hurt is real and very strong in a lot of places. I don't know where people get off thinking they have a right to be offended. No, you choose to take offense.
Right.
You choose what offends you.
I agree with that.
And if in a professional setting you're getting triggered and offended, what the hell are you doing in this profession anyway?
Right. The other thing that I think that's important too, and this is an element that's missed by a lot of clients, and that is basically preserving your evidence, preserving your information, preserving your documentation. And one of the things that I've seen as a paralegal is when a client walks through the door or a client gives a call on the phone and you ask them, well, do you have copies of these orders, or do you have this information that's there? They don't know. They don't have it, or they say they do, and then they don't. And I think that as a client, if you've got a legal situation that you're dealing with, go get your arrest reports if you've been arrested. Go get your court orders if you want to enforce a court order, whether it's a divorce decree or a parenting plan or a child support order. Get the most recent ones. Get a procedural history of the case. And the way you can do that is what's called typically it's called a docket printout, where you print the entire docket, which is the list of documents and dates they were filed. That is a great way for any paralegal or any attorney to look at the case and kind of see what the history of the case is. Because MGTOW Esquire, you hit the nail on the head, and that is that, a lot of cases people will come to the attorney to put out a fire that another attorney started.
That happens a lot. And on the subject, if I could digress briefly on the subject, we spoke the first time hiring an attorney. If you're looking for an attorney just to consult with, you might want to take a look at their webpage and see how many areas of law they quote unquote specialize in. If that number is much higher than 2, they don't specialize in anything. That's a pretty good red flag. If you see a sole practitioner in particular that handles more than one area of law, you're probably barking up the wrong tree with that firm. Right. It's impossible to specialize. There's there's too many rules and too many fact patterns that occur just in matrimonial or family law. I'm even considering narrowing it a little further. I mean, I want to help people, but there's a certain point where it's like, okay, I don't handle custody and support issues anymore. All I do is divorces, because at a certain point, the issues, you'll start to see the same issues repeating. And I'll be honest, it seems to me like the major pain is in the custody and support side, not as much as the divorce side. But if the divorce is handled correctly, the custody and support issues go away. If you're seeing attorneys multiple times, that means the case wasn't handled right the first time.
Right.
That's
right.
just the truth.
And we had this conversation the other day. What happens is that in the initial divorce, the law firm will do the divorce decree, they'll do the parenting plan, they'll do the child support order.
Right.
But it'll all be boilerplate language where they just plug things into a computer. The computer spits out, the boilerplate language in the forms, and then they take the forms in the court and they file it. The problem with boilerplate language is that it is overly generic, often ambiguous, and usually the parties will misinterpret what these things mean. So the ex-husband will think it means one thing, the ex-wife thinks it means something else, and then the court's like, this is too generic and it's unenforceable. Now you have to go in and file a modification proceeding. And really what you've done is, and this is the sad part, is that in the initial divorce, you got your divorce, but you never addressed any of the other issues that were relevant to that divorce. And now you have to address them now. And you may have paid an attorney $15,000 or $20,000 for that initial divorce, only to have him fuck you and to realize you got fucked 5 years later.
Well, and there's actually an addition to that. When you have a divorce, these documents you're referring to, parenting plan and what have you, they're not necessary in every single case. They're really not. You can get a divorce. You can file a judgment roll that is missing a lot of documents that would be helpful to know in the future. And if you don't have them, they're not there. Specifically, and I'll if you'll allow me, I'll digress one more step.
Go for it.
Specifically, if you went through a mediator, mediators are great. They're very helpful. Oftentimes, they don't have any legal training of any kind. Their primary function is to get two parties who are at war to make peace, which is a very good and helpful role in cases like this. But they'll prepare something called a memorandum of understanding or a actually, I think that's pretty much what they call it. Good ones will call it that pretty much all the time. And the way it is that basically shows that you guys came together and agreed on something. Well, a memorandum of understanding will allow a case to sail right through the courts, just like poop through a goose. It just goes through quickly. But what the order that comes out of that is based on the memorandum of understanding. And if the memorandum of understanding is in any way unclear, you're going to have trouble in the future, almost always. She runs off with Prince Charming and finds out Prince Charming is Jeffrey Dahmer, and so her focus is suddenly thrown back on the previous relationship, and he may have moved on as well, and now all of a sudden she's knocking on the door. And, you said you'd love me forever. Well, he's moved on. And now you've got a scenario where they're going to be warring forever. And they're looking for a way to ruin your new life. So if you get these things handled the first time through, that can't happen.
Well, and that's the other interesting thing that I think it's important to bring up as well, is that a lot of these, what we're discussing for those that don't understand or aren't understanding completely, the terminology here is called a post-dissolution modification proceeding. And what that means is that you're trying to either modify the parenting plan, or you're trying to modify the child support order, or you're trying to modify some other aspect of what happened during the initial divorce. And what's interesting is that MGTOW Esquire hit the nail on the head in that what happens is that these modification proceedings are very often filed once one party or the other gets a new significant other. So the ex-husband gets a new girlfriend, or maybe they're engaged to be married, or the ex-wife gets a new boyfriend and he moves into the family home that you purchased. This is the time where the modifications usually come forward, or there's some major incident with the kids, of course.
Right. Right. So it's critical to get it handled right the first time.
Right.
And it's really important. I will say that mediated settlements, they're great, but if the mediated settlement, if the memorandum of understanding, and a lot of mediators don't want you to be talking to an attorney. You get a mediator who doesn't want you talking to an attorney, you got the wrong mediator. Because what's going to happen is you'll sign on the dotted line, and then you'll go get an attorney, and he'll prepare a judgment for you that's basically unenforceable and useless.
Yeah, excuse me for just a moment. Xeranx, thank you for the subscription.
So yeah, it's just many of the mediators will work with attorneys if they know what they're doing. Most mediators have never even seen a judgment roll, and they've handled mediations for many years. They don't even know what's in them because they're not legally trained.
Right.
The good ones,
the other side,
the good ones will look for it actively.
Right.
But,
and the other side of that is that thank you for the donation, Carnage Con. I think that it's important for people to understand too that a lot of mediators are social justice warriors, and so you have to be very careful when you're in the mediation, because body language is important, communication style is important, and if you offend a mediator, they will turn on you.
Yeah. There's a few of them out there that are not, I'll be honest, most of the mediators that I've seen so far have been female. Most of them are pretty damn good.
Right.
I know of one that I have a feeling she may be red-pilled, which is really a shock and a half.
You're being spoiled then.
Yeah, I think I may be living in an area that's just got some extraordinarily good people here. I'm impressed, but I will confess, when I come across an attorney who specializes in 20 different areas, it rankles me a little bit.
Right.
But the mediators I've met are pretty impressive.
Now, I will say this. Sometimes there are attorneys, and I've contracted with a few. Sometimes there are attorneys that will specialize in multiple areas, but they are all related. So let me provide an example. You're a family law attorney, but you do criminal as it's related to family law. So maybe you do domestic violence, maybe you do child abuse cases, maybe you do bankruptcy, because bankruptcy is a common second stop
Almost
after
always
divorce.
tied to it. Yeah,
exactly. So when it comes to related matters or matters that cross over, I've seen attorneys who do specialize in multiple areas, but they do it because they're relevant to the work that they're doing, and they can keep all that work in house.
Yeah, exactly. And I'll be honest, with my firm, it's my intention to branch out into other areas. But when I do branch out, I'm going to have a dedicated attorney staff member who's going to handle just one type of law. I don't want that person branching out into other areas.
Right.
If they make partner or something silly like that, then I'll consider it. But no, I'm paying somebody to do a specific job, and I don't like mission creep.
Exactly.
So,
well, and it's one of those things that, if you specialize in quote unquote too much, then you've not really specialized in anything. And I think that's important. Now let's shift gears here. I know that you wanted to talk a little bit about the differences between paralegals and attorneys, and kind of let people understand that a little. Go for it.
Absolutely. And we did touch on it a little bit with regard to the theoretical nature of an attorney's work. Many paralegals, when encountering an attorney who is fresh out of law school, will be stunned and amazed by the things the attorney does not know.
That's true.
That is because paralegals, bless all of them, know the nuts and bolts, of the court system. These are the folks who actually know how to do. They'll know, the analogy, the doctor analogy. They'll know where the scalpels are in the hospital. They'll know where the pharmacy is when a new doctor comes in. They make an attorney's life so much easier, because you really don't want the theoretician to be handling every aspect of a surgery. Just like a general practitioner isn't a surgeon, similarly, a theoretical attorney isn't going to be a litigator all the time. They're also not going to be estate planning attorneys and drafting documents all the time. Whereas a paralegal can put an attorney into a position where the attorney is focusing primarily on the theoretical aspects of a case and the angles that can be played, instead of thinking about, well, we need to file this document here, and we need to do this one here. We need to get this piece filed with the county. This one has to get filed with the court. That's the kind of stuff that paralegals provide. They know, properly trained paralegals, and most of the ones I've encountered were properly trained, they know all this stuff before the attorney even considers those particular aspects of a case. You don't want the attorney to be thinking about those things. They should be handling the theoretical aspects of the case more. They're marrying the facts of a case to the law and the rules of the case.
And I also think, too, that it's important that when people are looking for attorneys, that they should make sure that the attorney, or try to find an attorney that has a paralegal. And here's the thing. Not all paralegals are actually paralegals. Some are like legal secretaries or receptionists, and they call themselves paralegals. So having that legal knowledge is absolutely crucial, because I mean, a paralegal is like the difference between, the paralegal attorney relationship is the difference between the doctor RN relationship.
Exactly. And you gotta be mindful that there's RNs, there's nurse practitioners who can prescribe medicine. And then there's also the LPN, which, and I'm going to offend every nurse out there if they want to take offense. The initials in common parlance to at least the RNs that I know is let's pretend nurse. LPN. Let's pretend we're a nurse. So,
damn,
it's brutal that nurses. Oh, it's a tough profession to be in. I feel for nurses because they do some really good work, but I'll be honest, they eat their own.
They do.
I've never seen a scenario where there wasn't a queen bee. I'm going to go a little bit off topic. Just go ahead and rein me in if you need to. But I've never seen a scenario where there wasn't a queen bee syndrome, where one of the nurses turns into Maleficent and starts trying to go after the licenses of their subordinates that they don't like. And oh man, I've defended those cases in the past, and they're so sad. They're so sad. The good cases of those types, you could actually find something that the Maleficent character has done something that would lose her license. So exactly. that's kind of the only fun scenario of that type.
Sure.
Because you just turn the tables on them.
Let's switch gears and let's jump into domestic violence and kind of some best practice. So in general, what are just kind of spitball this real quick, kind of do some shooting from the hip, and we'll just kind of get started with that. What are your thoughts on defending yourself against false allegations of domestic violence?
Record everything, cooperate with the police as best you can. Because the Duluth model is still in existence. It is a vile piece of, I think it's been codified through the Violence Against Women Act, and it's a vile piece of legislation because it presupposes that men are the only perpetrator in these types of cases. So the police have been trained, and it's young police officers who've been trained and haven't actually had the experience to know that it just isn't so. May act a little more hostile than the older cops who actually know it's bullshit. And there's, I'm not really talking nuts. I guess this is more nuts and bolts.
Right. Well, let me kind of jump in here a little bit as well.
Sure.
So first and foremost, when it comes to the idea of domestic violence in a civil setting, in a family law setting, it's all about the woman's feelings. It's not about the facts of the matter. There is no empirical definition of domestic violence. And what I mean by that is that you could be found guilty of domestic violence in a family court or in a civil court without ever being criminally charged. And so basically it just takes the judge to agree that a woman felt afraid, or she was concerned, or let's say she tried to walk away from an argument and you grabbed her hand and said, hey, don't go. Or it could be you raised your voice and she felt scared. Or, maybe you were upset and you gave her a mean look. I've seen all of those things translate into domestic violence restraining orders. I've even seen a particular scenario where the husband and the wife traditionally had rough sex. And I'm not talking like BDSM or anything like that. I'm just talking about rough sex. And the wife had a couple marks left on her as a result. No police report was filed. And the husband's like, yeah, we had rough sex. I mean, that's just what we do. And the judge is like, all right, you've just admitted to DV. Here's your conviction. Your civil conviction, not a criminal conviction. But I think that the point I'm trying to make is that If you're in a situation where you're in a relationship with a woman and you feel like the communication has broke down, you feel like the investment is not there, and I'm talking about like after a period of time, or you're in a situation where you're speaking and she won't listen, and you feel like, oh, I just need to turn her around, or I need to, block the door so she doesn't leave, or that kind of thing, because you really care about her. Don't. Just let her go. Accept the relationship is over. Yeah. And move on with your day, because any of those things can find you guilty in a civil court in a protection order situation where you get a domestic violence restraining order placed against you. And the problem is that in most situations where a civil domestic violence restraining order is filed, you get no right to remain silent. You get no right to confront your accuser. You get no right to an impartial jury to review your case. You don't even get time to defend against it, because the domestic violence protection order system typically is on a 14-day accelerated basis. And you need to understand that the domestic violence hearing, it's not a motion hearing. It is a trial. And typically the man does not have an attorney present and is testifying by himself, which means he is waiving his Fifth Amendment right to remain silent. So you have all these challenges in place. You have all these, because you're basically being accused of a crime. Now, what ends up happening is that once the domestic violence order is in place, and once they have that, they can go back and get those transcripts, and then they can take those transcripts and they can bring them to the police, and the police can open up a criminal investigation, which sometimes happens, and then they can try to criminally prosecute you for domestic violence. Now, even though you have those rights, they'll look at the transcripts and see you've waived all those rights, and then you're fucked.
That's true. The on the subject of the protection order, one of the tactical things that you really want to try and do, if you can, if the facts will support it, is try to get a reciprocal protection order. Because if you have a one,
you just cut off there, MGTOW Squire. Are you there?
A reciprocal. You've got one on her and she's got one on you. Order of protection, because then if she comes into your place of business, you are suddenly, she's violating her order, as opposed to the situation where she's got one on you and you don't have one on her. She can go anywhere she wants, but you have to leave. That's pretty awful. And she can actually be there and phone, she can be there with you without you even knowing and phoning the police, and they'll come and get you. You don't want that. You really don't. You're in a position there where you've got some serious issues going on. You don't want that to happen ever if you can avoid it. And the other thing, which this does lead me to the next point, there was a fellow on TFM's show that had I think he had 2 passports or something like that. But the scenario that he was in was going to end very badly, and he wound up leaving the country. Happily so, even though it was a pretty dark circumstance that led to that. But the way in which my suggestion is that if you start to get the feeling that somebody's going to file a domestic violence order against you, if you think she's that level of crazy, maybe even if you're not and she's just unhappy with you, you might want to keep a personal calendar book and notate where you are and if you have an alibi. Because having an alibi to confirm that you were where you say you were, and even having a calendar book to say, hey, I wasn't there. I was asleep 100 miles away in a hotel for that time that she's alleging I did this. That's past recollections recorded. It's one of the exceptions to the hearsay rule. It is admissible evidence. So you want to make sure you document where you are if you think you're going to have this kind of stuff. Just having a calendar book to notate and maintain your affairs, just so, when you get that question, where were you on the 29th of September? Well, you know where you were, because you may have to testify about that.
Right. And the other thing is,
it seems crazy, but this is a crazy world we live in. I'm sorry, I didn't interrupt. Go ahead.
No, you're fine. I think it's important for people to understand that those are the things that are relevant. The other thing that I would say is this: if you're considering getting into a committed relationship with a woman, not that I recommend it, you need to learn about her history. In other words, does she have a criminal history? Does she have a mental health history? Has she been institutionalized? Does she have a drug history? All these things are absolutely important because they go to the credibility of her false allegation against you. And again, I'm not talking about allegations where you just decide that you're going to give her, 5 across the face. In those situations, you're kind of on your own. But I'm talking about the false allegations where nothing has happened, or she's blown things out of proportion or taken them out of context to create a false allegation. And in those types of scenarios, you need to know a little bit about her history. You need to know a little bit about her background. I worked on a case where a guy was falsely accused of domestic violence, and it turned out that the woman who was accusing him had filed domestic violence restraining orders against 4 prior boyfriends, and she herself was criminally charged with domestic violence like 8 years previously. So you have to understand that you never know what you're going to get. And sometimes the woman who looks like she's the girl next door, or, the one who looks like she goes to church all the time, they have history. So you need to be very cognizant of that type of history, because she's not going to tell you. It's like going to a job interview. Do you walk into a job interview and be like, yeah, I have a half a bottle of tequila every night before I go to bed, and occasionally I'll kick the neighbor's dog. They're not going to tell you that. So there's and the other thing, there's ways to find out these kinds of things that don't involve stalking or anything like that. You can ask a completely innocent and innocuous question that will seem totally innocent and innocuous, but really isn't. One of the examples that I have, my arsenal of tricks, is the simple question that you would ask a date. What's the hardest thing you've ever done? Well, if their response is, "Oh, it was so hard to when my husband left me," or whatever, whatever bullshit story they come up with, if they start pointing to things like that, you might want to ask a few more questions, because she might not tell you that, yeah, I cheated on him and fucked him over and divorce raped him, but she will tell you, and she'll act like a victim. And if she starts acting like a victim when you first meet her, you can bet she's going to be a victim when you leave. So that's just a tip, pro tip, I guess. There you go.
Get to know who they are.
Now, the other thing that I would say as well is, if she is filing a domestic violence protection order against you or makes the allegation in family court, I would request the family court, or whichever court is there, to put a stay on the action and to recommend law enforcement get involved. You see, because the judge can actually send a referral over to the police department and have them investigate. You don't want family court services investigating. You don't want any kind of parenting investigator investigating. You don't want anybody from the domestic violence department investigating. You want a police officer investigating. The reason that is because the criminal definition of domestic violence is very well codified in the criminal laws of whatever state that you live in. So having a law enforcement investigator go through and go, yeah, there's not enough to charge here. Now you can go back into the family court, or you can go back into the domestic violence court and go, look, the officials have investigated. They basically have said she's full of shit. I need to go about my business. But if you allow any of these other agencies, organizations, or individuals to do this, 19 times out of 20, it's going to be a feminist with an axe to grind. And her bias is going to taint the case, and you're fucked.
Yeah. So, and that gets back to the have an attorney so they can control this better for you.
Exactly.
They can control who's going to have access to interviewing.
Right. So, you have any other thoughts on the whole idea of DV and that sort of thing?
Lots of them, but none that are articulable right now. So I'm just gonna say, let's move on to whatever other topic you wanted to talk about. Or the Q&A.
Yeah, I think we're almost ready for the Q&A. The thing that I would also tell people too is that if this is your first Layman's Legal Clinic, check out the very first Layman's Legal Clinic that MGTOW Esquire and I did, because it is fantastic in that it helps people. Like if you need an attorney or you're concerned about, your legal situation, definitely look at it, because it has a lot of valuable information there. All of them actually do, but I think that they're extremely important, because the first one tells you kind of what to look for in an attorney, what to avoid, in finding like once you find an attorney, whether or not that attorney is going to be worth your time, and kind of gives you some general tips on how to interview that prospective attorney before you hire them. I think that all of those things are extremely relevant, and I definitely recommend checking those things out.
Absolutely.
So let's move on to the Q&A. Lone Wolf and Rose, what do we got?
I got something to put out real quick, and then we'll get to Rose. Okay, guys, for the questions. First of all, proper grammar. If you do not use proper grammar, I'm throwing your question out. If it looks like you let your 6-year-old sit at the computer and type it up, and I have to try to translate what you said, I'm throwing it out. I'm going full sober cat on the questions.
Wolf, you may want to consider a second career as a comedian. That was funny.
No, I'm actually being dead serious. Also, use the brackets and question, and make sure you say who the question is directed at, whether it's MGTOW Esquire, DDJ, or both. Okay, and proper grammar, and no potato questions. All right, go ahead, Rose.
Okay. This one's a bit of a potato question. Are traps gay?
Yes.
Okay. Yes. That is my legal opinion.
Yes, traps are gay.
And,
If you listen, if you have a dick and you like dick, you are gay. Next question.
How different is the education between a lawyer and a paralegal? Is one more intense than the other?
I can speak to the legal side, definitely. I bet DDJ could do the same. Is that addressed to me? I jumped in. I shouldn't have done that.
They didn't say.
Okay. Go for it there, MGTOW Esquire.
Okay, well,
I'll dovetail.
An attorney's training involves, first thing you got to do is you got to have a college degree of any kind, oddly enough. One of the fellows I trained with was trained as a parapsychologist before he Ghostbuster before he came into law school. And then you take the LSAT, Legal Scholastic Aptitude Test, and then you start law school. That's a 3-year intensive program or a 4-year. The nature of the training is almost 100% theoretical. They're trying to get you to understand by reading cases and asking questions or answering questions, how they're trying to teach you how to think like a lawyer. And thinking like a lawyer involves a very simple acronym, IRAC, Issue, Rule, Analysis, Conclusion. If a lawyer doesn't think like that, they're not going to pass the bar. You have to be able to concisely spot an issue, say what the issue is, state the rule, be correct as correct as you can. Many attorneys, and myself included, will sometimes shoot from the hip on the rule because a legally trained bit of common sense can give you a pretty good idea of what the law is. Oftentimes it's right. Sometimes you're not quite right. So shooting from the hip can be dangerous for an attorney. And then analysis is you're basically fitting the facts of the circumstance that you're seeing and into the law, the rule that you just got through stating, and then you have a conclusion. This is or is not. This is or is not the probable outcome in court. And like I said, it's 3 years. The stuff they teach you is civil procedure, an excellent class. I wish every layman could at least sit through 5 minutes of it just to understand why they don't want to be a lawyer, because sometimes it's bone-chillingly boring. But it's very important to know that stuff. And then you start talking about the substantive areas, torts, criminal law, and there's also criminal procedure.
Right.
I heard somebody whispering in the background.
Yep. I got somebody talking to me for a second. That's
the legal side, and there's 3 years, and then you take the bar.
Right. Now, I will say this: when it comes to the paralegal piece, there's a lot of variety in your paralegal training. Typically, a paralegal course is a 2-year college course, like at community college. But what I've seen. So what a lot of bars, like state bars, are attempting to do is they are attempting to start to regulate paralegals a little bit because they want to give them standing, but they also want to bring accountability to the table for like unlawful practice of law. So what's happening is that I've seen paralegals where they take the 2-year course and then they get their paralegal certificate. However, I have seen in some places where in order to get your paralegal certificate, you have to have a bachelor's degree first. In those jurisdictions, do not get your paralegal certificate. It is a waste of your time and money. Go get your bar card, because your paralegal is 2 years, your law school is 3, and go from there. Now, the other piece I would say too is that when it comes to law schools very much deal with, like what MGTOW Esquire said, they deal with this idea of concepts and the conceptual side and theoretical side. However, if you go to night school and you go to a law school that is a night school, you're going to find more litigators who are professors in those particular schools, and you're going to get a lot more practical knowledge. The other piece I would say is that the lifeblood of a paralegal and the lifeblood of an attorney is not just learning the court rules, in other words, learning your civil procedure, but it's also learning your rule of evidence and learning your local rules. So in other words, you're going to have your civil procedure at your state level. So let's just say, for example, Washington State. You're going to have civil rules of procedure there, but you're also going to have a set of criminal rules, and you're going to have rules of evidence that provide that are relevant to both civil procedure as well as criminal procedure. And then in addition to that, when it comes to family law, you're going to see that many jurisdictions will also have additional civil rules that really drill down what's allowed in family law and what is not. So these things are extremely important, because if you don't follow the procedures and you don't know the procedures, and especially if you don't know the local rules of practice, you're going to end up filing documents, or you're going to create documents for your attorney. He's going to go into the court and he's going to trust what you're saying as a paralegal, and he's going to get sanctioned for it. So the thing that's important is this: when as a paralegal, when you are working for an attorney, their bar card is in your hands. So there's a great deal of responsibility that is there, and you need to make sure that you go out of your way and set those men up for, and women, set them up for success. And again, having that paralegal knowledge is important. But the thing is that even if, like, so I never went to an actual class. I was actually mentored and apprenticed through attorneys and through other legal professionals. If you're interested in going to paralegal training, or you're interested in learning about it, then I would suggest that whatever jurisdiction you're going to be working in, go get yourself a full copy of the court rules for that jurisdiction, in other words, that state. Get yourself a federal copy of the court rules for the circuit court of that state. So, for instance, the Ninth Circuit is Washington State. So you get Washington State court rules, you get your federal Ninth Circuit court rules, and then you'll get your addendum for the local rules for any county that basically you're going to be working in. And you need to make sure that you update those every year, because the judges will get together and they will change the rules. So you have to make sure that you're up on the addendums, and those things are extremely important. Because again, the paralegal is more the practical side. They're more the drafting of the documents, the legal memorandum, and those types of things, so that the attorney can focus on the theoretical or the conceptual. So, basically think of the paralegal as the sergeant and the attorney as the officer. The sergeant provides the information to the officer so the officer can make decisions for the entire team.
Yeah. And it's important to note, and DDJ did, I think he hit on it. If I'm being redundant, I don't mean to be, but the simple truth is one of the reasons why there's such a low bar sometimes, and in some jurisdictions, you don't need a certificate. One of the reasons of that is that no matter what, any legal work product that comes out of a law firm has to be reviewed by the attorney before it's filed.
Right. And
an attorney who doesn't carefully review every document that goes out is going to lose his license at some point. He's just going to. That's malpractice, and at some point it's subject to sanction by the court, and they'll take it very seriously. Exactly. So what DDJ is saying is absolutely correct. It's another reason why it's a good idea to have a paralegal if you're an attorney.
Let's move on to the next question.
Would either of you guys recommend installing cameras in your home to provide evidence of your innocence if you are accused of something?
That one's a tricky one. It's addressed to both of us. There's elements to that could be useful, and elements to that could be problematic. I hate that word problematic, but it's probably the most accurate term. If you got like a kitty cam, a little teddy bear or something that has a camera installed in it, and you actually use the kitty cam to monitor, say it's on every time there's activity in the room. Having that would be helpful, because the real reason that you've got it there is to make sure your child's okay in the care of a nanny. And you actually record that you had an argument with your girlfriend, and she's going to fly off the handle of me nuts. Well, you could use that as evidence, especially if you're in a one-party state. But these are things that are, it's kind of state specific, and it's there's good arguments and bad arguments for having them. Well, I have that camera there to make sure my girlfriend doesn't give me a false allegation. Well, that's probably going to be more of a case of, well, is it single party state or two party state?
The other thing that I would say too is if you're really hip on having cameras, it's a two-party state. Put up a sign on the entrance of every entrance of your place, or at the perimeter of the property, or preferably both, that says that you could be under surveillance at any time, and by staying on the property, that you are granting permission to do so.
Yeah.
That covers you and goes from there. But honestly, here's the thing. If you really think that you need cameras to protect yourself from DV, you need to get the fuck away from that woman, because if you don't trust her, don't be with her.
Yeah. If you don't trust her, there's no point. Don't even try.
Yeah. Don't waste the money. Don't waste the time. Don't look for the GPS. Don't deal. Just get the fuck out. All relationships are built on trust. If you don't trust, the relationship doesn't exist.
Yeah. And the minute you start to not trust, ghost, pop smoke and ghost, just get away from her as fast as you can.
Yeah. So I noticed that there was another question here. I'm going to move forward. There was another question here that's basically, I think it was Fedorable that asked, and I don't remember. But it says, how much is needed to sue for the Duluth model? This is something I brought up last night during the TFM show, and it's that a lot. I would say a couple $100,000, because it has to go to the federal Supreme Court, and it's not going to fly until it gets to the federal Supreme Court. So you have to understand, and more importantly, the other reason it's going to cost a lot of money is because the second that you go after the Duluth model, every feminist organization in the world is going to be wanting to file a friend of the court brief, or they're going to want to enter in as a defending party.
I would say the war chest needed for that is akin to the war chest that Google and Twitter and Facebook have to fight these kinds of cases. So that's a case that's all the marbles in the world. You start going after that, the number of enemies that are going to line up, and they do view you as an enemy.
Yes.
Not an opponent, not an ideological opponent. They view you as an enemy. And they are going to go after, they're probably going to have people who want to kill the attorneys prosecuting that case. They probably have people who are going to want to kill anyone who's going to evidence or testimony against it. They're not going to be reasonable. That's going to be a war, not even a battle.
And you're talking about people protesting outside of everybody's houses. Oh, yeah. You're talking about being harassed,
and bullets being fired into houses.
Exactly.
Oh, yeah.
Exactly.
That's if you take a look at the what's the name of that kid out in California? The judge handed down a 6-month sentence he was a swimmer. If you look at what happened, that's going to happen to anyone associated with such a case going after the Duluth model. That's the level of vitriol you're going to see, because the uninformed people are not going to understand what's actually being fought, and it's going to be mischaracterized as you're trying to take the rights away, and you're defending child. They're going to allege everything they can possibly allege if you go after that.
Yep.
You have to have such a war chest. It's kind of in the fuck you money category,
right?
To go after them.
Fuck you money plus $1 million.
Yeah, exactly. So yeah, 100,000, a couple 100,000. Yeah, I think that's a very generous.
Well, and the other thing that I would say too is anybody who was considering suing over the Duluth model, frankly, I think getting together and dealing with a bunch of conservative organizations first, and getting a bunch of organizations that are there first, I think is going to be extreme.
Yeah, you're going to have to marshal an awful lot of resources to even attempt such a thing.
Right.
And you have to be extremely clear with those organizations exactly what you're trying to do. So it's kind of going to be a massive sales pitch organization attempt to just even scratch the surface, and it's probably going to be a very long war. Not little battles. You want to chip away at it to get that to get straightened out. But anyway, that's just the facts of the matter. It's a lot. It's very similar in large measure to what's going on with Southern Poverty Law Center and the stuff that's going on with Google and Twitter. That's you're going after all the marbles. That's a biggie. That's right. Whew, I think we probably beat this one to death, but yeah, that's
we have
a little case.
All right,
you can't get a solo practitioner to take care of it.
No, definitely.
Would you happen to know about what a sailor could do if he's being divorce raped while at sea? I may or may not have a junior sailor in trouble.
I'm going to assume that this is not a merchant marine, but a military. I think that when it comes to being out at sea, first and foremost, you have to be able to have time to be served. Definitely, you want to get an attorney, and definitely you want to make sure that you're covered there. And understand the military, they don't give a shit about you. They're going to side with her because they're very gynocentric. So, especially the Navy, where there is no wrong hole. I think that it just, you really have to just, you need to make sure you have an attorney. You need to make sure that if you're out at sea, that everything is stayed until you get back. Because what's going to happen is that they do this all the time. So like on the West Coast, they do what's called Westpac, where the attorneys or the sailors will go out on a ship and they'll be there for 3 to 6 months out at sea. And then, the wives go run rampant. And you see this a lot on the West Coast. And then the guys end up coming back and they've got, a DV order against him and everything else. And she's lied about all this kind of crap. And then you got to go through and you got to go and do like what's called CR60 motions to vacate orders and things like that, because it's all dog shit. It turns into a shit show. The reality is that you can't stop somebody from attempting to divorce rape you. But what you can do is you can defend against it. And I think that when it comes to a legal issue, you have to plan on the worst case scenario in order to hope for the best. And so when it comes to those types of scenarios, having a competent attorney is extremely important. And frankly, I think that if you're married and you have an intact relationship, I think that it's going to be important that to really have some money set aside. Have some money set aside that you don't tell your wife about. Just not a huge amount, but a small amount, enough for a retainer, so that if you do get waylaid one of these days in a divorce rape setting, you have a retainer ready to go to give an attorney so that you can be protected. And this is just, it's rainy day money.
Yeah, exactly. Let me also throw in there is a statute, an act called the Soldiers and Sailors Act. If you're away on a ship for months and you're not a soldier or a sailor, there's a little bit of protection there. But I will tell you that it can be gotten around. There's some very unethical attorneys who've done some very unethical things and achieved service in contravention of that act. And what'll happen is, if you're an active duty soldier and you're going out on patrols, you come back, your commanding officer is going to have a copy of the pleading that you've just been served with, and he's going to order you to sign that, because he can't have somebody out on. He's going to order you to just dispose of it, because he can't have soldiers out there with their minds on other things. It is absolutely unethical to try and get around the Soldiers and Sailors Act, but it's there for a reason. Every single pleading is going to have, the question of, is either party in the military? And if that gets checked, it has to comply with the Soldiers and Sailors Act, because you can't be getting judgments against people who are of any kind, against people who are overseas and defending their country. You just can't. That's not the way it works. So, but boy, oh boy, when you come back from active duty, you can be in for a surprise. So, and a lot of people don't know about the Soldiers and Sailors Act, and I'm not sure the military even tells them.
No, they don't. I mean, I've heard of it, but again, it's one of those. Hold on.
You cut out.
Sorry about that.
We're still there, right?
Sorry, I've been having some sound issues. So it's one of those scenarios that the military doesn't even tell you about. They just expect you to know. So, but with that said, let's move on to the next question.
All right. I'll be taking over the questions from this point forward, and I'll have some input on this particular one because even I know the answers to this. And you guys can correct me if I veer off. All right. Question from Disjunctive 12. I received an interrogatory essentially asking for full disclosure of witnesses and experts as well as what they'll testify about. Is this not something that must be answered? It seems pretty low. And the answer is that both sides have to know the same things. And you guys can correct me if I'm wrong about that.
Let me kind of touch base on this. So in certain jurisdictions, there's two parts to this answer, and then MGTOW Esquire can kind of clean up and correct us if we're wrong. So the first part of this is first and foremost, when it comes to interrogatories are written questions that are provided from one party to the other to be answered under penalty of perjury. So they're sort of like it's like a short bus version of a deposition. And part of interrogatories is that you're required to provide documentation as well if they ask for it. So like bank records, things like that, or other records or documents that are relevant to the situation. Now, when it comes to the interrogatories, typically in most jurisdictions, you see it's going to be somewhere around 20 to 30 days to respond. Those are calendar days, not business days. And in addition to that, in some jurisdictions, you are required to submit updates to the interrogatories should information change. And they shouldn't have to necessarily ask you for those updates. You have to provide them. So if something changes and you don't give them the update of the new information, you could be held accountable for it if they choose to pursue it. But yeah, definitely you have to answer their interrogatories. And if you have an attorney with you, the attorney will know what to object to and what not to. Because sometimes you can object to a particular question on a variety of grounds, but typically it's going to be an attorney or a legal professional that's going to be able to understand what the objections will be and under what circumstances that you.
Yeah, there's a whole host of objections that you're going to want to put in there regardless, because if you don't raise an objection when it needs to be raised, it's waived. And similarly, if you don't update, particularly if you're updating it with favorable information to your side, the other side can make a motion to foreclose. It's called a motion in limine. They can make a motion to foreclose your ability to bring out this positive information, to keep it out of the evidence. So you don't want to ignore discovery ever. You just don't want to do it. It doesn't end well if you do.
Yeah, it's better to do it. It's better to respond early than late.
Yeah, definitely. And accurately, as accurate as you can, and also with the objections that need to be made.
Right.
The courts have no sympathy for objections that weren't made on timely fashion.
Okay,
let's move to the next one.
Yep, and that's why you should have an attorney and not do it per se. Next question is also from Disjunctive 12. I have a support adjustment hearing coming up. I'm working as a W-2 contractor on a temporary contract and no benefits or paid time off. Can this be taken into account when calculating child support?
Theoretically, it really depends. I mean, typically with a child support adjustment, so smart attorneys, what they'll do is they will do a child support order. In many jurisdictions, the child support numbers will change based on the kid's age. So usually it's like, I'm just spitballing this here. Usually it's going to be like from birth to like 12, and then from 12 to 18, or from 10 to 18, something like that. And then the child support schedule changes based on the kid's age and, of course, the number of children that are involved. Now, when it comes to child support adjustments, if they're trying to raise or lower the child support, typically they'll look at what your current job is, but they'll also look at your history of employment. So, for example, let's say you're a carpenter, right? You're a union carpenter, or you're a union pipe fitter, or you're union laborer of some type, and you get dispatched out of the union hall. So sometimes maybe you're making 40 hours or 50 hours a week. Other times you're working 60 hours, and then other times you're just kind of laid off and you're not working, and you're just kind of waiting in line for your turn to get dispatched from the union hall. They look at the history of your or they should be, I should say, in a best case scenario, they should be looking at the history of your employment to determine what your child support or what your contribution to child support should be. So if you have a history of not working and then all of a sudden you are working again as a contractor, it really depends on how long that contract is going to be, and it really depends on the specific facts of the case as well. Now, the other thing that I would say is this. One of the things, and this is something I've said in a previous Layman's Legal Clinic as well, and I've also said this on the PFM show. They look at household income. They typically don't look at individual income in the majority of jurisdictions in the United States. And so what that means is that if your ex is living with her mom and her dad, or living with her boyfriend, or living with whomever, right? They look at the entire household income. They don't just look at her income for purposes of child support. And oftentimes, the father or the ex-husband can use that to lower his child support as well. So that's just kind of something to think about. MGTOW Esquire, do you want to jump in here?
Yeah, this is a very theoretical, or rather, I should say, very fact-specific question that's been asked, and it's also extremely jurisdiction-specific.
Yes.
If you're trying to deal with this by yourself without an attorney, I advise against it. That's not something that you want to try, and that's definitely not because courts have tools like imputing income.
Right.
If you're not familiar with what that term means, imputing income means they look at your work history and say, well, this is what got people like Robin Williams and some of those other ones. Well, you were working and earning $1 million or hundreds of $1 millions that year, so you can work to $100 million this year, and boom, you're suddenly charged with $100 million, even though you haven't done that type of job in 5 years. You don't want to get hit with something like that. You want to have an attorney on your side backing you up, and even those men got hit with it, and they had attorneys. So be very careful with this kind of case.
And I'm looking at Disjunctive 12's chat message right now. He says he does have an attorney, so that's good.
He does have an attorney. Okay, good. Yeah, it's there's an awful lot of landmines in those in modifications, child support modifications. There are almost never modifications to go down that are brought by the ex-spouse. It's almost inevitably going up.
Always, yeah.
So,
all right.
I mean, if you do have a reasonable and sane ex, I realize that I'm describing a unicorn. But if you do have one, I've had cases where that does happen, or a spouse that earned more money than you. You can certainly do a modification petition with a stipulation, so that sails through like poop through a goose when it happens. It's just the facts on that case, they're so rare that it's just like that never really happens. It doesn't. So keep that in mind. I mean, if both of you are fighting over the you don't really have a if both of you don't have a pot to piss in, and you're fighting over the same bone, those cases get really ugly, and at some point they're going to realize there's no money to be had. But that depends if they're represented by an attorney who's private pay or if it's a legal aid society type. So,
right.
So just consider.
Disjunctive 12 says that it was brought by him because his eldest son is graduating high school. Once they're 18, yeah, that's the best time to move forward.
Yeah.
All right. Next question.
All right. This is a guy that types like a 6-year-old, so I cleaned it up. Carnage Con, and he didn't specify who it's for. In Chicago, blacks are predominantly charged with domestic violence. What advice would you recommend to reduce the risk?
Don't live in Chicago.
That's the best answer. We call California Dogshitistan. That goes for Chicago as well.
Exactly.
I mean, take a good solid look at who's the mayor. That should tell you everything you need to know.
Yeah, exactly.
It's the same as California. Take a look at the governor. That tells you pretty much everything you need to know.
All right, too easy.
That one was easy.
All right, the next one is from the Lord of Sweet Corn. And it's for both you guys.
Okay.
Got a friend that got his daughter taken away because his wife was found to be endangering the child. She is currently in a psych ward for the time being. He currently lives in Canada, a small British colony.
All right.
Any ideas?
All right. So let me jump in here. I actually saw this question earlier. I think this is from Kat. So
that's why I said
type 1 if Kat should take the sweet corn challenge, and then we'll go from there. So everybody type 1 for Kat to take the sweet corn challenge. Just man up, cross-eyed sweet corn challenge. There you go. All right, so let's answer this question real quick. All right, so first and foremost, I don't know Canadian law, but I will say this. In the United States, this shit happens all the fucking time. What has happened is, and just so we're on the same page, what happens is that mom will get custody of the kid after the divorce. Mom is batshit crazy, or she's got other issues, she's got drug issues, whatever the situation is. The state will come in, Child Protective Services will come in, they will snatch the kid under an emergency dependency order, and then they will start a dependency proceeding. Now, 9 times out of 10, they will not contact the father. They will not contact him under any circumstances because they don't want him to know. The reason they don't want him to know is because then the state can't justify taking the kid and putting the kid in foster care. What they end up doing is in a situation where the one parent is dog shit and the other parent is reasonable, what they end up doing is they have to place, pardon me, I had to grab something to drink. What they had to place is they have to place the kid in the father's care, because in the United States, under Troxel v. Granville, the parental rights, they supersede everybody else's rights that are there. So with that in mind, you have to understand that that's how it's handled in the United States. Now, in Canuckistan, where Justin Trudeau is paying millions of dollars to confirm terrorist because he likes to smoke cock and put on fake eyebrows, it might be a different program entirely. But I will say this. If the father is there, the father should number one, he should have a court-appointed attorney if they have that right up in Canada, or he should make sure he has an attorney, and he should be really pushing for his parental rights, because if she's in a psych ward, she can't have custody. If the Canadian state Child Protective Services has said, mom is not fit to be a mom, then he needs to push to have the child placed in his care, especially if he was, being a good parent before. But I will say this: if he's a drug addict, if he's got a criminal record, if he's got a history of child abuse, rape, sexual assault, or anything like that, at that point, then he's probably done. Probably not a lot he can do. But it just sounds like what they're doing is doing a child snatch order. Now, the most of the time when I've seen this happen, it's usually because the kid is of adoption age. And so sometimes these Child Protective Services workers, they moonlight for adoption agencies. So they get paid by the state. And then as they get these adoptions to go through, they get a kickback from the adoption agency as well. So there might be a conflict of interest there as well. But the challenge here is that it's Canada. Canada doesn't have the rights for the that the United States has. And on top of all of that, there's a lot of factual history that needs to be there, which is why he needs to have a solicitor or an attorney or whatever they call him up in Canuckistan. MGTOW Squire, do you want to weigh in on this?
Actually, you handled it extremely well. The one thing that you do want to, it's a procedural addendum to what DDJ said. He's correct in his interpretation. You absolutely want to do that, but you'll want to bring up writ of habeas corpus to your attorney. If they've handled any of these kind of custody matters in the past, they'll know what that means. Somebody in that situation should absolutely not, under any circumstances, try to handle it themselves. No. That's way too complicated to do alone. There's a very few select fact patterns that a layman can realistically expect to get through navigating the landmines that are in family court. Very, very few.
Yeah, and anytime the state's involved, you absolutely, no matter what.
They have the ultimate deep pocket because they can actually print money. Mm-hmm. So don't do that alone. The other thing, as a side note, hi Kat. Hope you enjoyed the whiskey. I'll keep looking to see if I can find another kind of whiskey that you might like. Yeah, I know. I think I may have to send him a smaller bottle.
I'll have to show you my meme about that.
That's funny.
Well, it's the best whiskey I've ever had, and I wanted to share it with Kat. So
There you go.
Glad he enjoyed it, but I think it may have been a little. Maybe he thought it was a mixer.
Yeah. Well, Cat does drink, so he says he loves.
Oh yeah, excellent.
All right. Do we have any other questions?
Yeah, we got probably 4 or 5.
All right, let's hit those up real quick.
Okay. I'm good with time for a little bit more.
Yeah.
Okay, cool. And guys, if you're going to ask questions, make them single questions, not multi-part.
Yeah.
All right. The next one is from Artemis the Kitten for both you guys. Now that there are more women in law school than men, will this make the whole court system more based on feelings than logic and reasoning, like MGTOW Esquire said?
Yes. Next.
That was
Yeah,
easy.
pretty much. Let me jump in here too. Just not on the question, but just kind of do a little bit of housekeeping. Just so you guys know, all the questions that have been gathered will be all the questions that are going to be asked, and after this, we'll close the stream down. But with that in mind, I'd also like to thank everybody for watching the stream today preemptively. And if you are an Amazon Prime member, feel free to subscribe to my channel. It costs you nothing if you subscribe via Twitch, and it does benefit me. So it's free to you, helps me out, and it's a win-win situation all the way around. So with that in mind, let's jump to the next question.
All right, cool. I guess I'll ask this one. It's from Carnage Con again. Any way to protect yourself from false criminal charges and accusations?
Yes, with a criminal attorney.
Pretty much.
Easy. Okay.
Well, and let me kind of add. I mean, I know that sounds like a kind of a short, FU answer. Let me elaborate a little. The thing about a false criminal charge, you can't prove a negative. In law, you can never prove a negative. However, in criminal court, they have to prove beyond a reasonable doubt. Now, one of the things that they will attempt to do is, especially if they're operating in bad faith, is they will often attempt to basically, they'll jail you for an extended period of time. They'll try to harass you on other charges. They'll hope for a plea bargain, all those types of things. The reality is that whatever attorney that you hire, and you damn well better hire an attorney, he has to know the rules of evidence. He has to know the case law for the jurisdiction, and he has to be an experienced trial attorney. If he is not an experienced trial attorney, you will get steamrolled. And that also means that if you're hiring a public defender, you're probably going to get fucked as well. It's better to hire a private attorney who knows what he's doing, who specializes in criminal defense than anything else.
Absolutely.
All right. I guess we're ready for the next one. This one's from the Way Monkey. Is it foreseeable as artificial intelligence is implemented into various industries that the paralegal profession may be augmented through software programs?
It already is.
Yeah.
I mentioned it earlier.
Yeah.
Relativity.
The AI programs are definitely there, but they're out of the reach of most law firms at this point. But also the other side of it is that there are a lot of attorneys out there who can't find work, who end up working as paralegals for larger law firms. So even though that is there, a paralegal who knows case law, who knows how to do case law research, who knows how to think like an attorney but has the practical knowledge, is indispensable to a law firm. And I don't anticipate them being replaced anytime soon, because the reality is that do you want a research attorney who you're going to have to pay $150 to $300 an hour, or do you want a paralegal who you can pay somewhere between $25 and $50 an hour?
Yeah, and there's a further addendum. Even if, let's just say for the sake of argument, that software packages like Relativity, which are able to research, basically, it could in probably about 10 minutes, once it's fully trained, search through the entire Library of Congress for the cloud terms that would be relevant to a case, and it would also be able to isolate things that would be privileged, arguably. But the amount of data that Relativity is designed to sort through is so voluminous that a human being couldn't possibly search through it. So, I mean, if you were to do propound discovery on Google, you're asking for every memo, every document that's responsive to the question. So the amount of data they're going to have to sort through, some of it's going to be privileged. Some of it's stuff that's private conversations that they've managed to sniff their software's managed to sniff that was occurring between their users. That's probably not going to be something that's responsive, but it might be. The fact that they're keeping it would be, or might be keeping it, is another issue. And then, so it's so much data that a human being cannot, even a team of attorneys wouldn't be able to do it in 100 years. But an AI software would be able to do it, and they do. The way relativity works, I think I'm calling it by the same name, the correct name, but for the sake of argument, I'm just going to say it's relativity. The way it works is amazing. And so, yeah, the AI has made litigation that would have been a 20-year-long case possible now. And it happens in a much speedier. Electronic discovery is a huge field right now.
Yeah,
so
really is.
Yeah.
All right. Next question.
And I must admit, I'm thinking that was probably Turd Flinging Monkey. And if it was TF Monkey, hey, dude.
There it is.
I don't think it was him. But
okay.
Real quick, how many more questions do you want? Because we've gotten some more. I know we're running shorter on time.
Let's go with 3 more questions, and then we'll close the stream.
That works.
Okay,
that's good.
All right, sounds good. All right, the next one is from another Canadian. I'm going to shorten it. Will it be possible to sue false accusers out of existence when they presently? He's basically saying, will you be able to sue false accusers that control academia, because he brought up something that happened at a college in Canada? What would be a careful prediction on that?
I think in Canada it's going to be a lot harder, because I'm using as my guide to this answer, I'm using the Jian Ghomeshi case from British Columbia. So Jian Ghomeshi was like the most popular TV personality in Canada. He was friends with Cuck Trudeau. He was a huge social justice warrior. He was also in the sex positive BDSM community type of thing. He was falsely accused of sexual assault by 3 women who conspired to set him up. And what was interesting about this is that these 3 women were backed by major feminist organizations. So these feminist organizations were able to run a negative media campaign against him in the press. They were running protests, they were running events, and they were smearing him in every way he possibly could. Well, then when discovery happened in the criminal case, they found out that these women had been conspiring to set him up for false allegations, and they had found 5,000 emails between them when it came to that. Now, the reason why this is important is because after he was found innocent, the feminists got Canada to change their laws to make it a lot harder to defend against false accusations of sexual assault or rape or anything like that. Now, why is this important? Why is this relevant? It's relevant because specifically in Canada, academia is absolutely inundated with social justice warriors and everybody else. Now, in the United States, for example, when you look at the Title IX witch hunts and things like that, Betsy DeVos, she went out and she canceled the Obama letter, which started a lot of these witch hunts and gave the green light. But what you're going to see is that these colleges are going to continue to violate men's rights as much as they possibly can. They're going to continue to violate due process rights, both in the United States, Canada, and anywhere else where this shit's been adopted. And so I think what you're going to see is you're going to see it get a little bit worse rather than better. I think in Canada, like UK, Australia, any place where social justice absolutely dominates, it's going to continue to get worse. In the United States, we're starting to see a retreat from a lot of this stuff, because a lot of these guys who've been falsely accused, they've been suing them into the Stone Ages. They have just been suing the ever living shit out of them. And like 70% of the lawsuits in the United States have been. So anybody who's been falsely accused of sexual assault or rape on a college campus, and the college has gone after them as well, I would encourage you, if your laws support it, to speak to an attorney about it and to find out, especially like Canada, UK, Australia, that kind of thing, and to see if there's something that you can sue for that's recognized in those countries. But I definitely see them trying to make it worse.
Yeah, that's correct. The trends here in the U.S. have a little bit more hope than the trends up in Canada. I wouldn't bet much money that you're going to be able to realistically see any changes in Canada, especially with Cuck Trudeau or whatever. I think you actually had a better litany to describe him than I did. So I bow to your superior insulting skills for Trudeau. But yeah, I don't see a bright future anytime in the near future in Canada. But yeah, here things are a little better, at least looking a little better.
Exactly. All right, next question.
All right, this is a great question. I'm actually interested in the answer. If you run your contracts through a LLC, can that be used as personal income or for alimony?
Yes.
Yeah, I think you can.
So here's the thing. Most LLCs are set up as S corporations. So in other words, with an LLC, you can set up as an LLC as a proprietorship, or you can set it up. Typically, I would say probably about 90% of all LLCs are they opt in for the S corporation. And what people don't understand is that S corporations mean that at the end of the year or at the end of the tax period, all the profit from the LLC flows to the individual via what's called a K-1 form.
Yeah.
So what's going to happen is that you're going to see the LLC money or the LLC profits flow to you, the individual. Now, I will say this. When it comes to those types of things, child support, like the IRS, uses global income. So, and they have a little bit of flexibility to determine what is income and what is not. So even if the IRS doesn't consider something like, say, for instance, like a gift, they don't always consider gifts as income. There are certain situations where they don't. In child support or in the child support arena, they often will consider gifts as income. So you want to be very, very careful. And if you're going to try to hide money from child support and you get caught, you are completely, utterly, and absolutely.
Yeah, the fact pattern that would be required to hide assets that way, it's hard to come up with, but I can come up with one, but I just wouldn't recommend it because I'm actually reluctant to speak about it because that'll probably get people in more trouble than just, fully disclosing and dealing with it honestly and straightforwardly.
Yeah, there are ways to protect your assets, but you need to start early and you need to start
way early. Yeah, even the fact pattern that I'm describing would be a parent protecting a child, kind of a scenario. But I wouldn't recommend even trying that kind of a game because it's very fact specific, and the facts have to be absolutely correct for it to actually make any sense. So, no. The simple answer is don't even try it.
Right. Better to be as clean as possible.
Absolutely.
All right. Last question.
All right. This one's from Inca Pesa. Is there a method or procedure to reform or amend laws in the family court? How does new legislation get established?
This is a Civics 101 question. You want to address this, Sarah? MGTOW Squire?
Yeah, I mean, has this fella never seen the Schoolhouse Rock episode? I mean, I think you can Google Schoolhouse Rock, and it's pretty darn accurate. It might be handled by a state assembly, and then it'll go to the state senate, and then it'll be proposed by they originate in the House of Representatives of the state or the state assembly, and then it'll go to the Senate to get passage, and then it'll wind up on the governor's desk to be signed. Family court, that's the procedure, basically. You can talk to your assemblyman, send them a letter. They'll probably ignore you. You might get a Dear John letter in reply. Be careful who you vote for in the state assembly is, I guess, the best advice I've got for you, because you get some lunatic in the state assembly and you've got a problem. And case in point and evidence for that assertion, Nancy Pelosi. She's been there forever, and she's an absolute nutcase, and an embarrassment even to a state like Dogshitistan.
Right.
So, but some states really like their embarrassments, so they not only have Nancy Pelosi, they also have Jerry Brown. So they are who they are.
And there you go.
How they managed to get elected? Well, I couldn't tell you. why they keep getting reelected, I couldn't answer that either. It's an embarrassment nationally that they're there. But that's
so basically, in a nutshell, the state legislature proposes a bill. The bill gets debated on, and then eventually it goes to a vote if it gets past the debate, and then it goes to the executive branch to get signed, governor of the state.
Yeah.
So that's pretty much the nuts and bolts. And check out Schoolhouse Rock. I'm Just a Bill.
Yeah, there you go. That's the name of the one.
Yeah, I'm Just a Bill. And it's pretty basic. Yeah.
It's pretty much the procedure in all the jurisdictions in the U.S. There might be some modifications. Some states are closer to the Napoleonic system, where the common law doesn't really prevail as much as the codified law. I think Louisiana might be like that, but I don't even know. They might be shifting right now. I have no idea what Louisiana's like, so I really shouldn't be talking out of my hat on this. But that's basically the procedure that you're talking about. And if you really want to do that, that's kind of an MRA thing to be looking at. You'd be lobbying legislators. That's the way to do it.
Right.
Good luck. That's just the truth.
Right. And with that said, thank you everybody for submitting your questions. Obviously, we're coming up on about an hour and 50 minutes right now. MGTOW Esquire, it is always a pleasure to have you on. Thank you for continuing to do Layman's Legal Clinic series.
Absolute pleasure to be here.
Perfect. Roseblades and Lone Wolf, thank you for helping out with the Q&A and helping out the audience. Everybody who tuned in live and asked questions and participated, thank you for being here. Just kind of a little bit of a shill alert before I go. If you look down on the bottom of the screen, you're going to see links to support me on Patreon. There's also a MGTOW group on Minds.com. If you have a Minds account, you can feel free to join that there. Of course, there's a link to my book, The Feminist Lie. It Was Never About Equality, as well as a link to my Bitchute account. If you have not subscribed to my Bitchute account yet, please do so. In case I'm targeted by YouTube, you can still get my content. And also, it's important to subscribe to the Bitchute account, because Bitchute will actually notify you when I upload new content in chronological order, whereas YouTube has changed their algorithm. And so they don't always notify you when I upload new content, even if you ring the bell. So if you subscribe, you ring the bell, they might not notify you if I get if I upload new content. But more importantly, sometimes YouTube randomly unsubscribes people from my channel and from other channels out there. So just be aware of that as well. And then finally, to kind of reiterate from earlier, if you're an Amazon Prime member and you want to support my channel, feel free to subscribe to me on Twitch. It costs you nothing, and it sure helps me out a lot. So with that said, thank you guys, everybody. And again, MGTOW Esquire, thank you. Do you have any final words before we go?
Oh, thank you very much for having me on. This is always a pleasure. And I guess the show alert I have would be look for attorneys that don't charge for the initial consult. See if you can find out what you need. Don't try to go this way alone. It's the potential pitfalls are astronomical. That's my show alert.
All right. And then Roseblades and Lone Wolf, do you guys have anything that you'd like to say in closing?
I think you cut out.
Yeah, I didn't hear any of that.
I was going to say Roseblades and Lone Wolf, do you guys have anything you'd like to say in closing?
I don't think so.
Okay.
The only thing is the bell thing. You might have to click on it and actually set it to every single upload, because I think there's another setting that says occasionally, and it might fall on default onto that.
Good to know. Thank you. And Lone Wolf?
Nope. Thank you all for being here.
All right, guys.
Thank you for moderating and providing us a more smooth stream. This is awesome. Thanks.
Yeah, absolutely. And I know the stream took a shit again in the middle. Apparently, that's a technical issue I'm going to have to work out. But I'll be putting the streams together so that it'll be one upload. And then once I do the post-production on that, I will upload it to YouTube, and it will also be uploaded to bitchute.com. Thank you again, everybody, for tuning in today live, and we'll go from there. I hope you guys enjoy the rest of